Okay, I have locked it so that no one else can join. It's now streaming live on YouTube. So let me now share the YouTube so that people can follow the online discussion. 1 second. Okay, here we go. Okay, I have locked it so that no one else can join. It's now streaming. Okay, I will post the live link on in case you want to give someone to join. Otherwise, okay, thank you very much. All right, thank you very much. The online interview. Well, sorry, I know this then to be very clear. Okay. So, okay, we are ready. But it's better the way you have it before, the light. Yeah, that's good.
It's okay now?
Yeah, it's okay now.
Okay.
All right. Good evening, viewers. You are welcome to Elomba Television virtual interview. Barrister Aloy Ejimakor. Barrister Ejimakor is special counsel to Mazi Nnamdi Kanu, the leader of IPOB, Indigenous People of Biafra, who is now in detention in Nigeria. Barrister Ejimakor, you are welcome to our program this evening.
Thank you, Daniel. I'm happy you have me on.
Right. Our guest tonight, like I said before, is Barrister Ejimakor, special counsel to Mazi Nnamdi Kanu, leader of the Indigenous People of Biafra. So, Barrister Ejimakor, can you please introduce yourself? Although everybody will know you by now, can you introduce yourself to our listeners?
Well, you've done the introduction perfectly well. So I think it's better we get straight to the point.
All right. When last did you see Mazi Nnamdi Kanu, please? Could you tell our guests?
What was that again?
What was the last time that you saw?
Okay, well, I saw him yesterday, and I spent almost 4 hours with him. He was in high spirits. Everybody knows the tribulations he has passed through, but he remains in high spirits. His spirit is strong, and he's looking forward to the opportunity of overcoming his present predicament. Tribulations.
So, what is the reason why the Nigerian government is the reason why Nnamdi Kanu has been following the other arrests in Nigeria?
And he's looking forward to the opportunity. Okay, you're asking me the reason it was rendition?
Yes.
Well, as everybody will recall, this whole thing has a causal effect that goes back to September 2017. As of September 2017, Nnamdi Kanu was free on bond. And then all of a sudden, the Nigerian government, which is a party to his criminal trial, and which held an abiding legal interest in his ability or capacity to appear for that trial, took a very surprising action in invading his home. That very invasion was very lethal. It claimed 28 lives on the spot, a lot of injuries, including Nnamdi Kanu himself and his parents, and other people very close to him. There was an undetermined number of people that were taken from the location of the invasion to unknown locations. Most of those people, or some, have never up to this moment been accounted for. So there is a presumption or assumption of death as well, which if you add to the 28, that would be quite a number. So when this invasion was on, everybody knew Nnamdi Kanu was on location, but somehow, to his credit, he was able to avoid being killed, and he fled from that location. Well, let's just put it this way. It's human instinct in play here. If someone is invading your home and you don't possess an equal force to repel the attack, your first instinct as a human is to flee, to escape from the attack. And that's exactly what Nnamdi Kanu did. And you see, apart from the locale of the attack, the entire territory of Nigeria after that invasion became dangerous to him. I mean, that is the apprehension he has in mind. And I think it's a reasonable apprehension. It's reasonable for him to believe that the entire territory of Nigeria, which he did not control, but is controlled by the same government that sent the forces to his house, now constitutes present an imminent danger to him. So apart from fleeing the locale or the immediate vicinity of the attack, he was, again, to his credit, able to find his way out of the territory of Nigeria. And several months later, you know, the rest is history when everybody saw him emerging in Israel. So from there, what I believe should have happened after this incident are the following. One, the Federal High Court, which was seized of his case, which was conducting this trial, should have given Nnamdi Kanu or his lawyers, since he was outside jurisdiction, it would have been by way of motion, the opportunity to ventilate the reasons that he failed to take his trial the following month in October 2017. And that opportunity was requested in the form of an application to the court, which was backed by Nnamdi Kanu's evidence in chief, comprising of an affidavit that he deposed to before the High Court of Israel, explaining why he didn't take his trial in October 2017 and why he left Nigeria. Had that hearing been conducted or application been calendared for hearing, it's quite probable, probably more likely than not, that the court would have, pursuant or subject to the quantum evidence that would have been made available to the court, concluded that Kanu's absence from jurisdiction is not voluntary, but involuntary. The jumping bail has an element of voluntariness to it. You see, when you prediction of your trial, especially the forces were produced by a party to the criminal action, which is the government and its army, that ought to be considered that your absence from jurisdiction is rather involuntary. So any involuntary thing regarding his failure to appear should not be ascribed to him, and therefore it would be a misnomer to say that he jumped bail, especially when the party, the very party that is now benefiting from that notion that he jumped bail, is the same party that is complicit in the reason why he jumped bail, or in the reason why he did not attend his trial. So it will be double whammy for that very party to now benefit from it by conducting or subjecting him to this extraordinary rendition on the excuses that he jumped bail. I can't hear you. I can't hear you.
Can you hear me now?
Yes, I can.
Okay. Now, we will come to that extraordinary rendition in a moment. But when the Nigerian government claimed that Nnamdi Kanu jumped bail for the past 2 years, obviously they know where he was, they know where he has been.
Yes.
For the past 2 years.
So that brings me to the second thing that could have happened after this jumping bail thing. The Nigerian government could have applied to extradite Kanu from wherever he was. We know He was temporarily in Israel, and when he returned to England, it was public information.
Exactly. So, and Nigeria has extradition treaty with the United Kingdom.
Yes, Nigeria does. Nigeria has an extradition act itself, and there's one in England that applies to, the one in UK applies to the entire Commonwealth. So Kanu's extradition would have been considered under that law in UK that has well spelled out express provisions that guide extradition. The extradition is the only lawful path through which you can bring a fugitive or a suspect from one national jurisdiction to the other. Nigeria didn't do that. And it didn't do that. And when perchance Nigeria discovered that maybe Kanu was in Kenya, Kenya as well also has an extradition act. I think they have two. One applies to Commonwealth, the other one applies to other countries. Nigeria is a Commonwealth country, so it has legal standing, it has locus to approach a Kenyan High Court or the Attorney General of Kenya. Those are the two parties that should be approached under the Kenyan Act to extradite Kanu in a process that were given, in a proceeding that would have given Kanu the opportunity to produce evidence before the court on why he shouldn't be extradited to Nigeria. So, but Nigeria didn't do that, yet it resorted to this act, infamous act.
All right.
Of extraordinary rendition, which is prohibited under international law.
Yeah, we'll get to that in a moment. So, you said you met Nnamdi Kanu yesterday.
Yes, I was with him for almost 4 hours.
So, did Nnamdi Kanu narrate to you exactly what happened in Kenya?
Well, he did. The first time I visited him, that was last week, and I made that public. He was physically assaulted and abducted in the underground parking lot of the Jomo Kenyatta International Airport by several armed men that he suspected reasonably to be members of the Kenyan security agencies or security forces. They took him, blindfolded him, and a few people that wanted to come to his rescue because they probably surmised that the manner of the abduction was improper, were scared away by some statement that the individual being abducted has some connection to the Al-Shabaab terrorist group in Kenya. So people became a bit reluctant to intervene any further. So they blindfolded him and took him to a nondescript private home, not to an official detention facility, where they held him for 8 days and eventually turned him over to the Nigerian security agencies, who now took over and took him to Jomo Kenyatta Airport on Sunday, the 27th of June, and flew him as a lone passenger to Abuja. They left around 12 p.m. and arrived at Abuja in the evening. And during his confinement, he was held incommunicado. He was beaten, he was tortured, he was treated in degrading ways, in inhuman and cruel ways. So it is to the glory of God and his strength of character that he survived such indignities and terrible tribulations and physical assaults and the mental torture that he underwent for 8 days. A lot of ordinary men perhaps would have died in the process, but he didn't.
Did Nnamdi Kanu tell you how long he stayed in Kenya before being abducted?
Yes, he arrived in Kenya, I think it was 14th April. You see, even as Nigeria declared IPOB a terrorist group in 2017, all around the world, our members of IPOB as terrorists, including its leader, Nnamdi Kanu. There is no nation in the world that sees IPOB or members as terrorists. So Kanu and members of IPOB travel very freely around the world. So Kanu cannot be an exception. So he travels around the world, visiting some nations in Africa, Asia, Europe, and he was in the United States, and these things most of the time are public. So he arrived in Kenya approximately 2 months before the abduction occurred, or a little over 2 months. That was in April.
Did Nnamdi Kanu tell you why he traveled to Kenya in the first place?
Why would I ask him that? He's a private citizen. He has the right to travel anywhere he wishes to travel.
Did someone lure him there?
We can surmise it was either a private visit or maybe it has something to do with organizing members of IPOB in Kenya. I don't know, because he has quite a lot of commitment to the cause of self-determination. So it might have been related to that, or a private visit. I don't think it's relevant, because he has the right to go anywhere. And he traveled on his British passport.
So he traveled with his British passport?
Yes, not Nigeria. The passport, the Nigerian passport that the Attorney General was reeling off during his press conference was the one that Nnamdi Kanu had renounced several times during his broadcast. You just have to Google it. He renounced his citizenship. He renounced the passport. He said it pointedly. He was never going to use the passport, Nigerian passport anymore. That's what he said. I'm not saying that renunciation was effective, but he wasn't someone that was using Nigerian passport from a certain point in his life, from probably as far back as 2015 or 2016. Yeah. He was using exclusively his British passport.
Yeah, I wanted to ask that question. When you say that Kanu has renounced his Nigerian citizenship, what does that act of renunciation involve?
Well, I'm not saying that renunciation is effective, legally speaking. I'm just saying that someone who renounced his Nigerian citizenship verbally so many times during his broadcast cannot be reasonably be expected to be traveling on his Nigerian passport. But you see, that's really not something that is relevant here. But what is relevant is the fact that he traveled on, was not in possession of any Nigerian passport.
That's correct. Yes. So, and as a British citizen, what does UK law say about? Okay, let me first ask this question. Nigerian governments have said we have rearrested Nnamdi Kanu. Going by what happened in Kenya, will you call it a rearrest, an abduction, a kidnapping, or extramarital rendition? What is the correct term?
It's not an arrest. It's not a rearrest. It's an extraordinary rendition.
And what does that mean? What does that mean?
Okay, extraordinary rendition is the act of forcible taking or kidnapping by a state of a suspect or a fugitive or a defendant from one state for the purpose of transporting him or repatriating him from the state of the kidnap or abduction to the state of interest where he probably will be subjected to trial. It is extralegal. It looks like extradition, but it's not. Extradition is a legal pathway that requires a cumbersome proceedings. Rendition is extralegal, is illegal. Some writers and judges around the world and a lot of people, commentators of knowledge have declared it a crime by the state. It is seen universally by a lot of people of influence in the field as a criminal conduct by the state of international dimensions.
I remember certain cases where the United States of America renditioned some UK citizens suspected of terrorism. And I know how the UK government took up the issue with the United States government when they renditioned these UK citizens accused of terrorist act to Guantanamo Bay. It was a very, very, very serious matter. They viewed it very seriously. So how is the UK government treating these against one of their citizens, a UK citizen?
Well, whatever Nigerian government is accusing him of should be looked from the prison of the charges that were pending against him before he left Nigeria. There were just 4 counts. One was conspiracy to commit treasonable felony. The second one was treasonable felony by itself. The second one was defamation of the president of Nigeria, and the fourth one is illegal importation of radio equipment. Well, you see, unless you are bringing new charges, which expectedly Nigerian government might do, this rendition occurred or was grounded on the tenor of those 2 outstanding and extant charges. And none of those offenses is captured amongst the offenses that are considered extraditable offenses by United Kingdom. And none of them also is considered an extraditable offense by the Republic of Kenya and even Nigeria. Those offenses are the ones called offenses of political character, or offenses that go to a political opinion that such suspects possesses, but which the government of the day or his home government is seeking to suppress by means of punishment of some sort. And self-determination is recognized universally and within the laws of Federation of Nigeria as a protected political opinion. So both Kenya, which is now denying its complicity, and Britain, on whose passport Kanu was traveling, prohibit extradition for any of those 4 offenses for which Kanu was facing trial before he left Nigeria. So I think any legalities or judicial proceedings in Kenya, England, Nigeria, and elsewhere will be looking at that, not at any new slew of charges that might be an afterthought in order to relate back to justify why the extraordinary rendition had to happen.
So if that were the case, have any representations been made to the UK government on behalf of Kanu to say, look, you are a citizen, a crime has been committed against him and he's not being detained in a foreign country? What are you going to do about it?
Yes, representations have been made by my humble self to the High Commissioner here, because I'm located in Nigeria. So that's where I can appropriately bring representation on his behalf. Now, representations also have been made by his lawyers in the UK, led by Bindemans, which is a prominent law office or law firm in the United Kingdom. Those representations have been channeled to United Kingdom government through the appropriate agencies of the government that are concerned with what happened. And as we speak, everything is being processed. And I think they will all come to fruition, because Kanu cannot be different from any other British citizen who deserves some sort of consular assistance or consular protection in a circumstance like this. Now, this takes me back to 1984, when Nigeria attempted to rendition Umaru Dikko. The only difference between that of Kanu and Umaru Dikko was that Umaru Dikko was created and Kanu wasn't. Where the second difference was that it occurred on British soil. But in substance, both of them are rendition. One succeeded, the other one didn't. So now we look at the countervailing measures that Britain took in the wake of that attempted rendition of Umaru Dikko. Britain broke diplomatic relations with Nigeria for 2 years. It expelled the Nigerian High Commissioner in Britain and a slew of diplomats, Nigerian diplomats. It nearly arrested the CEO of Nigerian Airways. It arrested 17 men, out of which 4 were convicted, and they served hard labor for 6 to 10 years. And upon end of that, they were deported from Britain. So this one is something that I think will expectedly attract countervailing diplomatic measures. It might be a Pyrrhic victory to have the suspects in the jurisdiction through a means that is unlawful. But as the event begins to unfold, you now have to think of how you grapple with the consequential or the consequences, which would most likely look like the consequences that came out of the attempted rendition of Umaru Dikko.
So right now, Nnamdi Kanu in Nigerian detention is receiving UK consular assistance. Am I correct?
Yeah, he has requested consular assistance and intervention of the home government in Britain.
And they have intervened.
Excuse me?
And they have intervened. The UK government have sent they have received consular assistance now.
You would know that his matter came up for mention, I believe, in the parliament. I believe the whole thing is being processed, but a lot of times, I believe at this stage, much of what the UK government is doing is something that they consider confidential.
Yes.
And it's too early to predict the quantum of their intervention. But I read one of the information officers from the High Commissioner here in Abuja that some intervention is underway.
Okay, and the Nigerian government, have they indicated when Nnamdi Kanu will be when the trial will start?
Well, he was arraigned, and the arraignment is questionable, but pursuant to the arraignment, his next scheduled court date is 26th of July.
So what do you expect to happen on the 26th?
Well, just days ago, the Federal High Court made an announcement that the Federal High Court is going on vacation until September.
Yeah.
So it's very likely that his matter may be adjourned, because it may be considered a matter that is not fit to be handled by a vacation judge. Vacation judges handle very limited nature of cases, such as arrest of ships or cases bordering on fundamental rights. But if any motion is brought before the court, before 26, that implicates fundamental rights, I will expect that despite the vacation judge will hear his matter to that limited extent, but not to trial, not to take it to trial.
Expect Nnamdi Kanu to receive fair trial in Nigeria?
Well, the question is academic. As a lawyer, I don't believe that a jurisdiction that conducted extraordinary rendition can be trusted to extend trial to the subject that was rendered or renditioned. You see, I expected that, first of all, that day he was brought before the court, on 29 June, the court should have conducted an evidentiary inquiry as to how he materialized before the court after almost 4 years. But the court didn't do that. It proceeded with his arraignment as if he was arrested within the territorial confines of Nigeria. And the court did that without giving him benefit of counsel, even when the court was well aware that he had counsel of record. The information, the contacts of the counsel is there in the file. The Attorney General's office also has information relating to his counsel of record. So to conduct an arraignment without inquiring to how the suspect was suddenly before the court, a suspect the court knew was outside Nigeria. In that inquiry, the court perhaps would have found out that he was renditioned, not extradited. And no court of law would touch a situation where, through the means of an act that is considered internationally unlawful. So,
is that concerning?
So with what I have said, there is a diminishing or even a zero opportunity for him getting a fair trial. That's how he feels.
Is that concerning to you as his counsel? Is that concerning? The fact that he was, are you concerned that a court of law will arraign a suspect who does not have the benefit of legal representation and therefore did not go on to do what it's supposed to do? Are you concerned about that?
Yeah, that's what I'm concerned about, because the bench warrant that was issued by the Federal High Court and which grounded the rendition doesn't apply to Kenya or to some other country, because the Attorney General said that Nnamdi Kanu was brought into Nigeria through a cross-border collaboration. The Nigerian bench warrant doesn't have validity outside Nigeria. Who else to know this than the judge? I mean, the judge should know this. As a judge, judges are smart, clever, and intelligent, and they are well learned in the law. The judge or the court itself knows that the warrant it is issued once cross-border was mentioned. That cross-border element obviated or invalidated that warrant as operative or applicable outside Nigeria. So how can you entertain a defendant who is before you on a warrant that was executed outside of jurisdiction improperly? The only way that warrant could have tenor or some teeth or applicability is when you use it as the basic process or evidence in chief in requesting for extradition of that suspect. So what should have been before the court, or whoever was arraigning Nnamdi Kanu before the court, should have told the court, hey, here, my lord, we have a warrant or order of extradition from this whatever cross-border country that they never wish to name, but which was later discovered to be Kenya. But none of that happened. So this is what is challenging the notion that Kanu can ever get fair trial from this jurisdiction or under the circumstances. But there is a prospect for fair trial if the court agrees to conduct an independent hearing, a hearing independent of the charges Kanu is already facing. A hearing, a separate hearing, evidentiary, has to be conducted by the court as to how he got to be before that court.
Going by what you are saying,
that is the only way.
Is that what you expect to happen on the 26th? Going by what you have just said now, that should have happened on the date of arraignment. Now that Kanu has received legal assistance, I will suppose, we now expect what you have just explained to happen on the 26th.
We don't expect that, but it doesn't mean we are not going to request that.
Yeah, that's what I mean. That is, are you, his legal representatives, now going to raise up the issue of, my lord,
Of
how?
course.
Yes, you have made. You didn't make an inquiry. Why didn't you inquire how he came before? How he came to be before the court?
It's an issue that must be raised before we can go to trial. That was why I said in one of the press briefings I did, or an article that I published, that there won't be any trial. Some people were saying, oh, that they need the opportunity to monitor his trial. I said there is nothing to monitor. There won't be any trial until they resolve the issue of that extraordinary rendition. That's my point. If you jump the extraordinary rendition and take him to trial, that will be fundamental unfairness, and he will live in infamy.
So refuses to.
It will be violative of Section 36 of Nigerian Constitution. You see, when we are talking about this, some people tend to think that we are talking completely international law. No. Two laws were broken in the way and manner Kanu was forced back to Nigeria. One, the organic law, the ground norm of the nation, which is Nigerian Constitution, Section 36 of the Constitution, and other sections under Chapter 4 of the Constitution were violated in their black letters and spirit. And then the Nigerian Extradition Act, which contained provisions that would have prevented Kanu from being extradited from Kenya or Britain, was also violated in its spirit and letters. So we're not talking, international law absolutely. Municipal laws of the Federation of Nigeria were also broken. So this is what we expect the judge to take a very hard look at and consider whether jurisdiction lies to try Kanu for any criminal offenses in view of these violations that I have enunciated.
Okay, before I ask my next question, let me ask this one first. Has the prosecution authority in Nigeria amended the charge which they have against your client? Have they brought forth new charges?
No, we don't have any formal notification of that. They haven't done that. Normally, in a well-ordered system, and in order to try to contain the public backlash, we should have received some amended charges by now. So we're assuming that the charges wouldn't be amended, or maybe they will be amended and served by way of some kind of ambush in open court.
Yeah, because
you come to court and they serve you with amended charges, which lawyers consider to be an ambush. But it's okay. We don't have any right now.
Is that allowed under the Nigeria criminal procedure system? I've left the country a long time ago, so I'm asking.
Well, the judges are allowed. That's why shouldn't be allowed, because we are supposed to have due amendments before the next court date. But it usually doesn't have that way. They serve you in open court. Okay,
some Nigerians are asking this question because when the Attorney General of the Federation was announcing that Nnamdi Kanu had been brought back, I think he listed 8 issues why they brought back Nnamdi Kanu with cooperation of the said of international security services, and they are far above the original charges against Kanu. So what do you have to say to that? And now, but you are saying you have not been officially notified that the
yes. He listed some things that were never heard of before.
Exactly.
Yeah, but if you want to consider this as a strictly legal, it cannot a rendition. Let us assume that the extraordinary rendition was granted on some collective offenses. The Attorney General also mentioned the fact that the rendition was granted by the court. So that he said a retinue of new charges that have not been brought formally shouldn't be considered relevant to the legalities of this matter, because at this point, I consider those things purely maybe some.
Are you surprised that the federal government will have gone to, will ignore the normal due process of bringing back Nnamdi Kanu if they wish extrajudicial means to bring back Kanu to Nigeria? Is that concerning to you? And where does that place Nigeria in the eyes of the Committee of Nations?
Well, like I told you, that is conducted extraordinary rendition, doing chest beating. It occurs in bringing a suspect, but the consequences dire. You, a British citizen or citizens, it's for the purpose of torture, or to third countries for the purpose of torture. It's not taken kindly. We do have decided cases on rendition. Some of them we are not. Some of them are still in court. But the idea of rendition creates a burden, underlying offense for which you rendition that person. It creates a legal and diplomatic burden on the state that rendition the suspect to its jury. Nigeria will be an exception.
But the Nigerian government are saying that their actions are justified in view of what they term Nnamdi Kanu's incendiary and inciting comments that poses a threat to the corporate existence of Nigeria. What will be your response?
Well, I'm telling you that that justifies extraordinary rendition. Nigeria will no crime. If Nigerian government felt that Kanu needed to be processed for that, it's called extradition, and Nigerian government knows that, because Nigeria also has a law, Extradition Act, at Cap E25, Laws of Federation of Nigeria. So Nigeria believe that it is okay for when its own laws have similar provisions against what the bare claim or bare assertion that the government is correct in bringing him back because he has done. Don't forget that everybody is presumed innocent until it's proven out. So it shouldn't be a case of demonization. If you demonize the person, then just have to look at the body of laws that govern the issue, or laws that govern this issue. Is the Extradition Act of Kenya and went back to United Kingdom, then you look to the laws of United Kingdom. That's how it's done. Nobody is saying that have the right, the sovereign right to as of a fugitive back to Nigeria.
Why didn't they do that? Why didn't Nigeria go through that legal process? Why didn't they employ? No, my question is, in your mind, why didn't Nigeria foresee the backlash, this backlash you have just described, and say, no, we don't want that backlash, we don't want that bad name, let us go through the normal judicial legal routes to bring back a fugitive? Why did they employ this extra legal means of extraordinary rendition?
Well, you see, had attempted extradition requests in the past in Britain and failed. After that rendition failed, Nigeria formally applied to politicians that Nigeria accused of different offenses in Nigeria. Britain denied the request. And Nigeria, I think, also knows that a well-developed legal system that has listed the offenses, right, extradite anybody. And none of the offenses for which Kanu was standing trial is among the offenses for which he can extradite anybody from Britain. So that's probably why it resorted to the easier path offered by the extra-legal means, which we call extraordinary rendition.
All right, we'll be coming.
Daniel is getting back at my location, so it's better to conclude the interview. So I don't.
Yes.
Look like a ghost.
Exactly what I'm about to say. I'm just about to ask my final.
I don't think there's anything more for us to talk about. I thought if it's too long,
exactly what
boring to your listeners.
No, what I'm saying is,
beginning to look dark. I can't even see my face anymore.
Exactly what I'm about to say. That's what I'm saying. I'm just about to ask you my last question. You just took it from my mouth.
Okay.
Okay. Yeah. My last question to you is, what do you expect the UK government to do in this instance?
UK government will do exactly what its laws say it should do under the circumstances. It's also, I think it's also going to look to the law of nations, otherwise known as the international law. Britain doesn't play with her citizens, so it would not stand by and let this fly. So it will do what its laws say it should do under the circumstances. That's my prediction.
All right. Well, thank you very much, Barrister Aloy Ejimakor, Special Counsel to Nnamdi Kanu, and those who have been
Thank you so much, Daniel, for having me on.
Yeah, I thank you very much.
Again soon. Thank you. Bye-bye.
Very much, and I hope you stay safe in Nigeria.
It's okay. I'm sure we're going to talk again soon.
All right. Thank you very much. Have a good night. All right. Bye.